Good morning, Madam Deputy Registrar. Would you please commence proceedings?
Good morning, President. Thank you. Caribbean Court of Justice, Appellate Jurisdiction on appeal from the Court of Appeal of Guyana, hearing of appeal in CCJ Appeal GYCV number 3 of 2025 between the Attorney General of Guyana and Azad Meerza. The members of this morning's panel are Mr. Justice Anderson, presiding judge.
Good morning, Counsel.
Madam Justice Rajnos Lee.
Good morning to everyone.
Mr. Justice Jamada.
Hi, good morning to everybody.
Madam Justice Onaniwu.
Good morning, everyone.
And Mr. Justice Balkan. Judge, you're muted, Justice Balkan.
Good morning, everyone.
Thank you. May we have the appearances, please? Thank you.
Good morning, Your Honor. If it pleases you, Nigel Hawk, appearing with Ms. Mohini Sudama for the appellant in this matter. And Your Honor, with your leave, I'd like to apologize for the absence of Senior Legal Advisor, Ms. Rihanna Clark, and Ms. Shania Prasad, both of whom are affected by the influenza. Our sincere apologies for their absence. Obliged.
Thank you, Mr. Hawk. And of course, we understand the absences as explained by you. Thank you, sir. Is there to be an appearance for the respondent?
Sorry, Your Honor. Juman Yassin, associated with Mr. Tini Husti for the respondent, please, sir.
Okay, thank you, Mr. Yassin.
Thank you, sir.
Well, welcome, Counsel, and we are prepared to hear your oral submissions. We already, of course, are in receipt of your written submissions, but we're looking forward to hearing from you orally. And I believe that the order from the court had indicated the time that you have to make the presentations. So we look forward to hearing you on those. Before we start to hear you, however, I'd just like to take the opportunity to recognize and welcome our newest judge to the bench, Justice Arif Balkan. Justice Balkan, of course, was sworn into office on the 16th of October in his native Guyana. Many of you may have witnessed the ceremony at the same time or subsequently. Justice Balkan, of course, is a very well-known Caribbean jurist. He was called to the bar in Guyana, his native land, and he has worked in the office of the Director of Public Prosecutions. He has also served on several international human rights bodies, such as the United Nations Human Rights Commission and the Inter-American Commission on Human Rights. Justice Balkan has also been a judge on the Court of Appeal of Belize, and we are very happy to have him with us. And we welcome you, sir, and trust that you will have a very successful and enjoyable stay with us.
Thank you very much, President.
Very well. So maybe then hear, please, from the appellant, Mr. Hawk.
Oblige, Your Honors. Your Honor, this appeal, Your Honor, stems from a arbitral award. Well, a challenge to an arbitral award, but to put the oral submissions in perspective, Your Honors, with your leave, there was a first award which was made by an arbitral panel on the 15th of March, 2015. And subsequent to that, that arbitral award was declared null and void because His Honor, Mr. Justice Holder, ruled that the panel was not properly formed. Subsequent to that, there was a second award, and that award was made on the 17th of February. Sorry, I don't have the correct date. It was made in February of 2017. Again, against the government. But Your Honors, the challenge with the award on the second occasion was that Mr. Gonzalez, who sat on the first in the first panel, also sat and rendered an award in relation to the second panel. At the trial court level, before His Honor, as he then was, Mr. Justice Navendra Singh, arguments are advanced as to issues of possible bias, the likelihood of bias, having regard to the fact that Mr. Edward Gonzalez sat on the previous panel. The court, however, ruled on the basis that the panel that was set up by the court in relation to the second award was not properly constituted. As a consequence, the award could not be enforced. Thereafter, Your Honors, an appeal was launched at the Court of Appeal of Guyana, and by a majority of the court, I believe Our Honor, Mr. Justice Cummins Edwards, as she then was, she ruled in a minority that the award should go back to the court, the High Court, that is for consideration. But the majority ruled that it ought to be enforced, and they ruled that it ought to be enforced on the basis that the state apparently waived its right to object to Mr. Edward Gonzalez sitting on the second panel. Hence, we are here today, Your Honors, and the crux of this appeal, whilst it's a simple matter, is an important one, simply for the court's determination as to, on two bases. One, whether Mr. Gonzalez, having sat on the previous panel, failed to disclose that he sat on that previous panel, whether that raises the issue of a likelihood of bias. We say not actual bias, but whether a fair-minded observer looking at this situation would see that there's a possibility or likelihood that Mr. Gonzalez would have been biased in terms of his adjudication in the arbitral process. That is one. And the second prong, if I can call it that, is whether Justice Navendra Singh, His Honor, Mr. Justice Navendra Singh, as he then was correct to rule that the second panel was not properly constituted because, in His Honor's view, having regard to the agreement, the agreement between the parties, the arbitral tribunal ought to have been appointed not by the court, but by the parties appointing the various members of the panel. Your Honor, the thrust of our appeal rests on this fundamental point, and we hope we were able to persuade this honorable bench on this point. And the point is simply this: the issue is whether Mr. Edward Gonzalez, who was appointed by the court to sit on the second panel, and having sat on the first panel and rendered an award, whether he had an overriding duty at all material times to disclose that fact. Even as we sit here to hear this appeal, there's never been any indication by Mr. Edward Gonzalez as to what, if anything, qualified him or did not, or disqualified him from sitting on the second panel, because no disclosure was made. We understand the other side's argument to be, well, state, Mr. Hawk, the Attorney General, you sat by idly there, you did nothing, and based on this process, you allow the process to proceed, and as a consequence of that, you can't come now and cry foul, if I can use those terms, please, Your Honor. We understand that to be the general argument of the respondents. Our respectful submission in response to that is the general theme of our submission has been and continues to be. It is that the arbitrator, we respectfully submit, had a continuing and binding obligation to make that disclosure, even if we say we sat there out of, I don't know, shape.
Mr. Hawk, may I interrupt you
sorry.
for a second?
Sure.
Yes.
Yeah, quite apart from this issue of waiver, I'm very perplexed as to this issue of disclosure that you're hammering. And I'm very curious as to disclose what. Was the fact of Mr. Gonzalez's involvement in the first arbitration process unknown to
Okay,
all
so-
concerned?
Right. So, if I may, if you could just hold that question, please, whether Mr. Gonzalez's involvement was unknown. I just want to be clear. What we are considering here are arbitration decisions involving the same dispute between the same parties.
Yes, please, Your Honor.
Okay. So is there any new evidence produced in the before the second tribunal as opposed to the first?
Not that I am aware of, please, Your Honor. Not that I'm aware of.
Okay. All right. Sorry, I didn't mean to. I just want to get that clear. No doubt if there's a disagreement, we'll hear from the other side. I didn't mean to cut across Justice Vulcan. So his question stands, please.
Sorry, please, Your Honor. Is that Mr.
I think
Justice
you-
Vulcan, you were asking about the disclosure and the waiver. Sorry, I don't know if Your Honor can repeat.
Not about
Sorry.
the waiver. I wasn't asking about the waiver. I was, because the point that you've been making since you started was that there was no disclosure. And I'm asking specifically, was the fact of Mr. Gonzalez's involvement in the first arbitration process unknown to the parties?
Your Honor, when you say unknown, you're referring
Was
to
it a
as to whether-
secret? Was it?
No.
Yeah. And
parties-
unknown to, was it unknown to the state?
It wasn't unknown to the state, but I think an objection was made initially, but because they had filed for an enforcement of that award and the process, as it were, whereby Justice Holder ruled that the process was flawed, that issue, in our respectful view, was put to bed, for want of a better term. It is
But
when
I'm not
we-
following.
Before you go further,
Mhm.
please,
Sorry.
please, before you go, there's some clarification required. There was an objection, you say,
Yeah.
to Mr. Gonzalez. I'm not sure everyone pronounces his name differently. I hope at some stage we get it right. But an objection was made to his appointment in this second arbitration, and by whom? Is that what you're saying? I need to get that clarified, please.
An objection was made at around sometime in November 2016 to Mr. Gonzalez sitting on the panel. The 28th of November to be precise, by way of letter by the state.
Yes.
And that objection was to his sitting on the second panel?
The second, this is in relation to the second panel.
So this comes back to my question, Mr. Hawk. Disclose what? Because if you're saying they objected, they knew. So I'm not clear what you're saying he failed to disclose.
No, we're talking about the issue here of whether he sat in the first panel, rendered an award. We're saying, respectfully, we're not saying that the court will agree with us, but our submission is the fact that he sat in the first panel, rendered an award. He was then reappointed to sit on the second panel by His Honor, Mr. Justice Rishi Prasad, I believe. We're saying we had an issue initially because he sat in the first panel and rendered an award against the state. Him
I'm with
sitting
you.
on the second panel.
I'm with you.
We had
But
some disquiet
disclose
about
what?
that. The fact that
That's
he sat,
the bias is one thing, or the apparent bias, but you're saying that he failed to disclose. I'm not clear what you're saying he should have disclosed that wasn't known.
well, Your Honor, the issue of disclosure that we're seeking to address was whether he had a continuing obligation to disclose that he sat on the first panel without indicating that to the court. Justice Rishi Prasad, that is. Because, Your Honor, you'll see on the record, there was an arbitrator who was appointed who indicated sometime subsequent when an objection was raised that he was affiliated with the government, and as a consequence of that, he recused himself from the panel. I can't remember if it's Mr. The name is not coming to me now.
Mr.
my
Howard.
apologies. Mr. Howard.
His name was Mr. Howard, but these proceedings before Mr. Prasad weren't ex parte proceedings, were they?
No, please, Your Honor.
Okay, all right, thanks. Carry on.
So there's an objection lodged on the 28th of November, 2016. Is that
2016.
before Mr. Gonzalez sat on the second tribunal?
That was sometime after the sitting, just before a decision was rendered by the panel. A decision was rendered in February of 2017, and the objection was made on the 28th of November, 2016, I believe.
Do you know when it is that the panel sat?
The panel from
Yes.
the records, please, Your Honor, would have begun hearing this matter sometime around August, September, October, thereabout.
2016.
2016.
Yeah,
So the
you see
natural
that on
question,
sorry, President, I was
natural
just
question
referring
then,
to-
yeah, is why wasn't the objection made before or at the time of the constitution of the tribunal?
And that is an issue. Some of it I do not have to be candidly recorded. I don't have an answer for as to why the state did not participate fully in that process. But I got the impression from the letter of the 28th of November that is when the state became aware that a process was ongoing in relation to the arbitral process.
Yeah. Mr. Hawk, I see that there is a note, I believe it is correct. If it's not, please correct me, on the fly sheet on the 23rd of September 2016 that Mr. Kissoon appeared for the defendant.
Ms. Kissoon apparently appeared.
Yeah, and the arbitration was ongoing. That is the
Was
note.
ongoing.
So
Yes.
that so when you say August, September, I take it was sometime then that the arbitration proceedings began. So
Yes.
that sometime when Mr. Kissoon appeared for the defendant, then the state was aware, the defendant was aware that the arbitration was ongoing. Is that correct?
That is correct, please, Your Honor.
Okay, thank you.
So if we could go back for a minute, Mr. Hawk, to my brother's question. He's asking you, the state is aware, let us take it, that Mr., is it Gonzalez?
Edward
Gonzalez?
Or Gonzalez. Some people say Gonzalez, some people say Gonzalez.
Okay. The state became aware that he was involved in the second tribunal, but you're saying that he didn't disclose that to you. My brother was asking you, if you already know, the state knows that he's involved in the tribunal, what is the value of him making a disclosure if you already you disclose information that the other side doesn't have or doesn't know, right? So what is the point of asking for disclosure at that point, or saying that he did not disclose when you knew the information that you wanted him to disclose?
You want in relation to the first, I don't know if I'm, you correct me if I'm answering, I'm endeavoring to answer your question.
Sure, yes.
In relation to the second arbitration process, it is my understanding when I look at the, I wasn't part of the state then, when I look at the fly sheet, it would appear as though it would have been some absences by the state. Yes, the state did appear, But why I was raising the issue of disclosure, and I stand to be corrected, I wouldn't press the matter if that is an issue, but it is to the point that Mr. Gonzalez sat on the previous panel. I could say probably mistakenly. I'm thinking in my humble view, he had an obligation, at least in terms of disclosing that fact to the judge who was making the appointment, that he sat on the previous panel that rendered an award.
So is it that the focus of this duty of disclosure for you, I know you say it's a continuing duty, is that barring your second argument that the party should have appointed and not the court having appointed the tribunal, the second tribunal, there was a duty at that point of appointment to disclose? Is that what you are focused on?
That is an argument that the Mr. Gonzalez was under duty at that point to at least disclose to His Honor Mr. Justice Rishi Prasad that he had previously sat on a panel and rendered an award at that point. So
can we just nuance that fact? At that time of appointment by the judge, was the state present?
I don't know that the state was present. I think the state became aware subsequent. Because from the fly sheet, Your Honors, I have to be candid with the court. It seems as though when the first hearing was called, I think the state was absent at that point.
So then, is it that your argument crystallizes around the idea to begin with that at the point at which the appointment of these arbitrators was made, the state was not present, and the arbitrator in question, Mr. Gonzalez, had a duty to disclose what, in your estimation, were circumstances that could reasonably have raised doubts as to his impartiality or independence on a second hearing. Is that what you're saying at that point?
That is what I'm saying at that point.
All right. Now, in terms of what the president, I think, is trying to also ask about a continuing duty, would a continuing duty have arisen if it was a circumstance that was known to everyone? Would the duty to disclose, I'm just trying to work out in my mind how you frame this, because this was not a party appointment, but a court appointment. Is that what you say taints the whole thing, and therefore the focus you put on disclosure becomes important, even though the state knew, because at the time of the appointment by the court, they were not present and so could not represent their objection?
Yes. That, and we say, Your Honor, we hope we could persuade the court. If the court is not persuaded, I will have to yield. But the fact that the state became aware, we're arguing humbly, I will say, that does not take away from the arbitrator to say, I previously sat on a panel indicating that to the court. Even at the stage of the 28th of November, when the state wrote indicating that we had a problem with this gentleman sitting on this panel, even at that stage, prior to the award being rendered.
I'm sure you're going to reconcile your position with the authorities, H&L, AMEC, and so on. But before we get there, could I ask you this? If the disclosure had been made, what then?
If the disclosure had been made, it would either have given the court the indication as to whether Mr. Gonzalez could have sat, having regard to the issue raised about possible impartiality on the panel, or on the second prong, if the state was there, the state could have objected vehemently to the presence of Mr. Gonzalez being there.
On what basis would the state object vehemently?
On the basis that he rendered a decision, he was aware of the factual circumstances pertaining to the arbitral process, having sat on a previous panel which a court rendered wasn't properly constituted. He was aware of all the factual circumstances and so forth.
So are you saying that because of his previous involvement in the first tribunal, he would have been ineligible?
No, I'm
to
just
sit?
saying that it would have raised the issue of a possibility of him sitting on the panel, and perhaps his impartiality could have been called into question, having rendered a decision against the state in the previous arbitral process.
So, no, fair enough, but could I press a bit further? So are you saying as a
Sure.
matter of law, he would have been incompetent, ineligible to form part of the second tribunal because of his work on the first?
Well, I should say, answer it in this way. In relation to the issue of possible bias, we're saying yes, in relation to, I'm just going, we're not in the second stage yet, where we think that Justice Singh, as he then was, ruled that he ought not have sat because the process in terms of selection of the panel was not fair, did not follow what the agreement provided for. But on the first prong, I would say yes.
You would say yes,
Yes.
that he became ineligible
Yes.
because he sat
There's
on
a
the first tribunal.
Based on the possibility that there's a likelihood that he could have been biased.
Okay, so, but you could, as a state, agree that he could sit.
He could sit. The state could agree that he
If
could sit.
the state consented.
If the state consented.
Yes. So this is where we get back to the problem of the state knowing
Yes.
and not objecting. I think that is a real issue. But how would you reconcile your position with the authorities, which appear to suggest that an arbitrator can sit on the first panel and the second panel in our case without, invalidating the decision of the second panel? I think H&L is one such case. AMIC is another. How would you reconcile your position with those authorities?
Well, Your Honors, the way we respectfully looked at it was, whether rightly or wrongly, the way we looked at it, we're being very candid with the court, was that here is a gentleman who was sitting on a panel, having rendered a decision in the first panel, albeit that panel was considered flawed by a judge. The fact that he was privy to all the factual matters in that previous arbitral panel, the fact that he would have been familiar with the witnesses and all of that, the basis of the evidence, and having now been appointed to sit on the second panel and rendered a decision again against the state, we are saying that those issues raised a possibility that a fair-minded observer looking at this situation may conclude or might conclude that he might not have been fair or impartial in relation to the rendering of his decision. More so, having regard to the fact that he was the arbitrator appointed by the respondent in both.
Yes, we have no difficulty following the clarity of your reasoning or your submissions. But what I'm asking you is how would you reconcile those submissions with the decision in AMIC, for example, which is almost on all fours with the position we have here?
Well, Your Honor, it might be that I'm trying to raise a novel point if the authorities are saying that. What we sought to do, because when
sorry. You're introducing a measure of doubt. When I say if the authorities are trying to do that, isn't that the decision in the AMIC case? And
yes, it's Your Honor.
Right.
And
okay.
all I'm simply saying is our position is yes, the state became aware, but I cannot say, I have to be candid with the court, what operated in the mind of those players at the time. What I know, the factual circumstances suggest that the state, whether it found itself after a while, did object on the 28th of November to him sitting on the panel. So clearly the state had some concerns about the member, Mr. Gonzalez, sitting on the panel. And that being said, when one looks at the scenario, we simply say that it certainly raises an issue in relation to as to whether Mr. Gonzalez could have been impartial while sitting on the second panel. I don't know that I've answered your question, but
Yeah, please go ahead. Yes, sorry.
President, if I may,
Please.
I'm not sure I heard the answer, but picking up where the president left off, Mr. Hawk. So the president has been asking you about the authorities, but I'm also curious about, I'm not sure what the word would be, if it's logic, but quite apart from what the AMEC case says, which, as the president points out, is almost on all fours with this. My query to you is, Mr. Hawk, is the mere fact that a tribunal, and this is an arbitrator, a judge, a jury, or whatever, is the mere fact that an arbitrator decides against one party in a dispute, does that mean that the tribunal is biased against that party?
well, no, please, Your Honor, but so case...
So that knows enough from me. So what I'm asking, in this case, other than sitting before, do you have, or does the state have, or can the state point to anything else to suggest that Mr. Gonzalez would not be fair? And the reason I ask this too, I note in one of your affidavits, and I'm sorry there were so many documents before, but I did make a note of the electronic number. It's on page 265, but I'm not sure what that would translate to in terms of the bundle. But anyway, paragraph 13 of your affidavit says, as a member of the board that made the first award, there's a real likelihood that he, and this is Gonzalez, he would not fairly determine the issue. And this is what worries me, or concerns me or perplexes me. You're saying, the state seems to be saying that if you've decided a dispute one way or against a party, that means you're not fair. And I'm not sure that, I'm following that if you've decided, you could have decided on all, you know, on the evidence and the law. Why does that equate to being unfair?
Your Honor, we're not saying that for 1 second that a person who would have sat on a panel may not be fair. Our argument really is that there's a possibility that there's a likelihood that a person who would have previously sat on the panel could be biased.
But should you point to something more? So, well, you know, some of these cases, like the president pointed you to some cases, you know, they were what emerged from those cases was where the arbitrator or the judge conducted themselves in such a way that would raise this. You know, in one case, he said quite infamously, I don't trust you as far as I control you, about one of the witnesses. Was there anything in the first proceedings that would raise this kind of suspicion around Mr. Gonzalez?
There's nothing, I have to be candid, there's nothing but for the fact that a decision was rendered against us and he again was appointed to sit on the second panel.
So it
Mr.
seems
Hawk,
like, sorry, go ahead, Judge.
No, please.
It's okay, it's okay.
No, I really just wanted Mr. Hawk to get clarity on something. It seems like you're equating bias with the likelihood of arriving at the same conclusion on the same facts. Are the two the same?
No, they're not the same.
Because you really are not pointing us to anything other than the possibility that Mr. Gonzalez would have arrived at the same conclusion he had arrived at in the previous case or in the previous hearing. And the term bias really is a loaded connotation when attached to a decision maker who is expected to operate with an open mind. And so that's why I think we're pressing you to understand if there's something other than the possibility that Mr. Gonzalez would have arrived at the same conclusion as an indication of apparent bias. But I think you're saying there isn't anything else the state is putting forward at this stage.
Yeah, I'm saying there's nothing based on what His Honor Mr. Bulkan asked in terms of, and Your Honor is asking, whether I have any other evidence or issues that I could point to see this arbitrator made adverse comments against the state. This arbitrator was conducting himself in a particular manner. I have to be candidly going to say I don't have that type of evidence. All I have is that he ruled against the state. That process was rendered flawed. I accept the position that not because you sit on a matter, you would be biased against a party and being able to sit on another matter. All I have, Your Honors, I'm being very candid with the court, is the fact that there's a possibility, there's a likelihood of him sitting again. He might not be impartial.
Thank you.
Obliged.
Okay, anything else on that first point, Mr. Hawk? You did indicate there's a second point to do with the contract and the appointments.
The second point, please, Your Honor, was in relation to the ruling of His Honor, Mr. Justice Devendra Singh, as he then was. And you'll see that the Court of Appeal by the majority ruling, I know only Justice of Appeal Gregory wrote a written judgment, but based on her judgment, she concluded that Justice Devendra Singh was wrong. I think she looked at it from the standpoint that he was seeking to review another judge's decision. Our respectful submissions that the judge's ruling was based on the agreement as per the first award. I believe the ruling of the court in that award, whilst we don't have a written decision there, was on the basis that the parties were not, at least the appointment of the panel was not in accordance with the agreement, which is, or was supposed to be, the appointment of the arbitrators ought to have been made by the parties and not the court. I believe the second process followed that same procedure. So whilst arguments were advanced in relation to the likelihood of bias before His Honor Mr. Justice Devendra Singh, an issue that he considered was whether the appointment of the arbitrators on the second panel was proper in all the circumstances. And we say respectfully that it appeared that the process again was not proper because, again, the parties were not allowed to appoint the arbitrators, as it were. But that is not. I have to go for it. That is not what we based our fundamental argument on. Our first argument was on the first point that I just raised with the court. That was on the issue of the likelihood of bias.
Yes. Can you remind us of the provisions in the contract which suggest that the parties were exclusively responsible for the appointment of the arbitrators?
Yes, please, Your Honor. One moment, please, Your Honor.
Yes, thank you.
So Your Honor's clause 26.
Yes.
26.1.
Mr. Hawk, could you just remind us of where in the record of appeal? I have a general idea, but if you could point us to the particular page, please.
It's on page 135 of the record. Sorry, please, Your Honor. And clause 25 and clause 26.1. Both on pages 134, I believe, and 135 of the record.
Are you able to display it for us on the screen? If not, could you summarize for us what it says? I don't have it in front of me, unfortunately.
Sorry, please. It starts with the procedure for disputes. It says because the first procedure, Your Honor, sorry, from as outlined in our submission, you had to address an adjudication process first. And I believe that process had failed because the parties couldn't agree on an adjudicator. But let me just read what it says, please, Your Honor, in correction. May you permit me to do so?
Yes.
It says the adjudicator shall give a decision within 28 days of receipt of a notice of dispute. The adjudicator shall be paid by hour at a rate specified in the special terms of the contract, together with the reimbursable expenses of the type specified in the special terms of the contract, and the cost shall be divided equally between the contracting agency and the contractor. Whatever decision is reached by the adjudicator, each party may refer a decision to an adjudicator to an arbitrator within 28 days of the adjudicator's written decision. If neither party refers the dispute to arbitration within 28 days, the adjudicator's decision shall be final and binding. The arbitration shall be conducted in accordance with the arbitration procedures published by the institute named in the place specified in the special terms of the contract. And then it says at 26(1), should the adjudicator resign or die, or should the contracting agency or contractor agree that the adjudicator is not functioning in accordance with the provisions of the contract, or the agency and the contractor, in the case of disagreement between the contracting agency and the contractor, within 30 days, the adjudicator shall be designated by the appointing authority in accordance with the special terms of the contract at the request of the parties within 14 days. I don't think that helps us, but there's a part that refers the matter to arbitration.
Mr. Hawk, can I ask you, how do you craft this in your notice of appeal? What is the basis that the ground that you put? Could you just direct us to that so that we understand where you...
Which ground?
Your
What
notice of
ground?
appeal, this very ground that you argue in your second point.
The second
About
point,
the improper appointment by the court. How is that put in your grounds? I'm trying to understand them.
that is not part of our grounds of appeal. Our primary basis for this appeal was on the issue of being very candid with the court, was on the basis of whether there was a likelihood of bias. To be frank with the court.
I understand. Thank you very much.
So the respondents nominated Mr. Gonzalez, and
Yes,
the court
yes,
accepted. The court accepted his appointment, and the appellant nominated Mr. Howard, and the court accepted it, but Mr. Howard then declined.
He declined.
And the appellant did not nominate anyone else.
No, please, Your Honor.
Okay, so the court stepped in and nominated someone in place of Mr. Howard.
I think the court appointed someone in place of Mr. Howard, and then those two parties appointed those two arbitrators appointed a third person.
And you're saying that the stepping in by the court to replace Mr. Howard is what rendered the constitution of the tribunal inconsistent with the terms of the contract.
I have to be candid with the court. That is not an issue that I was just raising that because that seems to be the basis upon which Justice Navindra Singh ruled that he would not enforce the arbitral award.
I understand, but you're adopting that as one of your bases for appealing. So I was just trying to follow through with understanding what happened and what you're objecting to. So instead of the parties appointing the arbitrators, the court stepped in to do so. Yeah. But did the contract allow the court to step in the absence of one of the parties making their nomination or appointment?
No, the contract speaks nothing about the court. So the arbitration act, I think.
Mr. Hawk, when they talk about an appointing authority, what are they talking about? In clause 26, when it refers to an appointing authority, what does that mean?
Your Honor, there's no definition in the agreement for what is an appointing authority. I assume here in this case, they're talking about, I'm assuming, I could be wrong, the parties to be the appointing authority.
But Mr. Hawk, after, to go back to the timeline, when Mr. Howard, who was the state had initially recommended him, and he then declined, the state took no further action. And correct me if I'm wrong, but it was at that point there was an originating summons to the court to settle this.
The respondent, I think, filed an originating summons.
Right. So it was in the face of the state's, for want of a better word, inaction, that the parties of one party approached the court.
Yes, please, Your Honor.
Okay.
And would that party be allowed to approach the court? Would the court be allowed to take action in the face of the inaction of the other party, if allowed to do so under statute, for example, the Arbitration Act?
I think the party always has the right to approach the court, but I think under Section 6 of the Act, I think that is the section
Yes.
came under
Yes.
to approach the court in relation to that.
Right. So having approached the court, what are the powers of the court in relation to the appointment?
The court has the power to appoint parties, I believe, under that provision, Section 6(1), I believe. I'm trying to just pull up the section to just get it correct.
Yes, that would be
wording of
helpful.
the section
Thanks.
for
Yeah.
the court.
Thank you.
Just a few moments, please, Your Honor. Sorry. So, Section 6 provides, Your Honors, in any of the following cases, namely A, where submission provides that a reference shall be made to a single arbitrator and all the parties do not have differences of arisen concur in relation to the appointment of an arbitrator. B, if the appointed arbitrator refuses to act or is incapable of acting or dies, and the submission does not show that it was intended that the vacancy should not be supplied, and the parties do not supply the vacancy. C,
what about subsection 2? Because I'm not sure all of that would be quite relevant.
2, if the appointment is not made within 7 days after the service of a notice, the court or a judge may, on an application by a party who gave the notice, appoint an arbitrator, umpire, or third arbitrator who shall have the like powers to act in the reference and make an award as if he had been appointed by the consent of all parties.
So isn't 6(2) an answer to the second round that you have raised? I'm sorry.
One moment, please, Your Honor.
Sure.
But in fairness, Mr. Hawk, I'm not clear that in answer to my sister, Justice Rajnath Lee, you said that you hadn't claimed this as part of your
It is not part of our grounds.
So I'm not. Are you really raising this, or?
No, I can't pursue it, as I was indicating. I can't pursue it honestly before this honorable court. I was just indicating that seems to be the basis upon which Justice Navindra Singh had ruled. I have to be candid with the court. Initially, I had a problem with the approach, and my simple problem with the approach was that I don't know that because he was a judge of concurrent jurisdiction, that he could have sat and determined that matter. I think it might have been better if the matter had been on appeal. That was just my initial view. So I just mentioned the fact that that is the basis upon which Justice Navindra Singh ruled. But no, to answer the question directly, no, it's not part of our grounds.
Well, thank you for that. It's just that it came to us, so we were hoping to
I'm
be enlightened. Yes, okay. Any further points you wish to make, Mr. Hawk?
No, those would be our respectful submissions, please.
Colleagues, any further questions? Mr. Hawk?
President, before we move off, just for the record, just to clarify, Mr. Hawk, you had been referring us to clause 26, but I just want to confirm that that clause relates to the adjudicator and not
The adjudicator.
arbitration. So I
Yes.
just wanted to confirm that. Thank you.
Yes.
Okay, well, thank you very much, Mr. Hawk. I don't see any of my colleagues wanting to ask any further questions. Thank you for your submissions. You'll have a chance to reply later, of course.
Obliged, Your Honor.
Thank you very much, sir. Can we move then to the respondent, Mr. Yassin?
Thank you
Thank
very
you.
much. Just to say it's a pleasure to appear before Justice Burkan in his first case.
Thank you.
Mr. Yassin, the roles are reversed.
I know.
And I recall having some very hard time in some cases.
I hope there's not be any reciprocity here.
Absolute no bias.
I think we spoke about that when you were here the other day.
Yeah.
Your Honor, I wish to say basically that the parties agreed when the matter came to the Justice Rishi Prasad that the court would be the appointing authority. And when the parties agree to arbitration, it is a contract between two parties. And the ministry and respondent agreed, well, look, the court would be the appointing authority. Your Honor,
Sorry,
well,
is that, sorry, Mr. Yassin, just to be clear, is that documented in the record anywhere?
no, Your Honor, it just is in response to what my learned friend was saying and some of the questions that may have been asked. Your Honor, my learned friend,
No, but sorry, so is that evidence that you're producing before us without mentioning the record?
well, I would say it comes from when one looks at the application under the fly sheet.
Okay.
And the parties agreed to do X, Y, and I'll come to that very briefly, Your Honor. I won't
Okay.
be I too long, Your Honor.
Yeah,
Your
not to detain you, but just to clarify just one point. So is Section 6.2 of the Arbitration Act relevant or could be relevant in a circumstance like this?
It is, Your Honor. It could be relevant, Your Honor. It is relevant.
Thank you, sir. Yeah.
Your Honor, my submission is that the ministry and the appellant were cognizant and they knew of the appointment of Mr. Edward Gonzalez. They were present on the 22nd of April, 2016. Counsel was present, counsel for the appellant was present in court when that appointment was made. The fly sheet, Your Honor.
The date again, please, counsel, sorry.
The 22nd of April, Your Honor. Let me. Yes, Your Honor. The 22nd of April, Mr. Ramlachan.
2016?
Yes, Your Honor.
Yes.
And Mr. Smith, who was a member of the Chambers of Attorney General, were present in court.
That was Miss Smith?
No, Mr. Smith, Your Honor.
Mr. Smith.
Mr. Smith. He's now in private practice. And after that, Your Honor, Mr. Gonzalez was asked to report to the court subsequently. And the fly sheet, if I can, Your Honor. After the 22nd of April, Your Honor, you have the 27th of April, 2016, where the Mr. Ramlachan for the respondent, and again, Mr. Smith for the appellant. And when Mr. Smith indicated that Mr. George Howard would be the arbitrator for the appellant. Your Honor, the matters were called on several days subsequently. And on a few occasions, counsel were there. Your Honor had indicated early on that on the 23rd of September 2016, Ms. Kissoon was present and indicated that the proceedings were ongoing. Your Honor, as I'm dealing with the fly sheet, and I don't want to waste the court's time, if you look at the 28th of October 2016, Mr. Ramlachan again present, Mr. Williams was the defendant, and there's a note here, arbitration completed. That's a report that was made to the court. Your Honor,
Mr. Yasin, what page is this?
oh, sorry, sir. My apologies, sir. Page 288 of the recorder. My apologies. Yes. Page 288. And it seems rather strange that a month after that report of the 28th of October, the letter has now been sent by the ministry objecting to Mr. Gonzalez. Your Honor, the ministry...
Mr. Yasin, before you go further, is there anything in the letter pointing to some recent knowledge by the...
Yes, Your Honor. Yes,
the appellant? Is there anything in that letter to assist us to say that they had just come into knowledge of this fact?
Yeah, Your Honor, the letter is at page 572 of the record. Let me just find it, please, Your Honor. And that letter indicates the first sentence. With regards to the above caption, subject, the Minister of Agriculture wishes to object to the arbitration panel that is currently carrying out arbitral proceedings for the following reasons. The word currently indicates that there was some knowledge of them that arbitration proceedings were being carried on. And then they indicated later on in the letter, Your Honor, and they were further on the last sentence of paragraph 1. Further, the order dated the 22nd of April 2016 and entered on the 2nd of May 2016, appointing Mr. Edward Gonzalez was never served on the Ministry of Agriculture, hence no objection could be made. So they were knowledgeable of the order of the 22nd of April 2016. And
the letter says anything, Mr. Yasin, about Mr. Smith's appearance and anything at all?
No, Your Honor.
He wasn't there, nothing. It just says that the letter wasn't, the order wasn't served.
That's all. The order wasn't served.
Thank you.
That's all. Your Honor, I wish to humbly submit that the ministry had full knowledge of the appointment of Mr. Gonzalez. And there are 12 notifications that went to the ministry. Your Honor, the first notification is found at page 509. That is a letter to the permanent secretary from the respondent. And this informed the ministry that Edward Gonzalez had been appointed arbitrator for the respondent. And at page 10, 510, Your Honor, there is a registration slip with evidence that this letter was in fact registered and sent to the ministry. Then the next communication, Your Honor, is on the 30th of June 2016. Again from the respondent, Your Honor, informing the permanent secretary that the arbitration matter, Your Honor, I'm sorry, this is found on page 511. My apologies, Your Honor. And the respondent was informing Mr. Jarvis, the permanent secretary, that the arbitration matter was in pursuant of the Union Circle rules, and that he will be informed by the chairman of the arbitration panel when meetings will be held. And again, you have the registration slip at page 512. The third communication, Your Honor, in which the ministry was informed, found at page 513. This was a letter from the chairman now to the respondent and the permanent secretary. And it indicated what had transpired in the court before Justice Rishi Prasad. And that Edward Gonzalez, George Howard were appointed arbitrators. And it goes on to indicate what had happened. Mr. George Howard had declined. And subsequently, Mr. Rutherford was chosen. Your Honors, the fourth, no, well, importantly, Your Honor, in the same letter, it gave the names of the composition of the arbitration tribunal, which included Mr. Gonzalez. The fourth communication, Your Honor, is found on page 515, dated the 3rd of July 2016. Again, from the chairman to the respondent and the permanent secretary, requesting the sum of 300,000 be lodged respectively. The fifth communication, Your Honor, was an email from the chairman to Mr. Rutherford, the permanent secretary, the respondent, Mr. Edward Gonzalez. And this is dated the 21st of July 2016. It stated, please find statement of defense attached. Your Honor, that was a mistake. It was really supposed to be statement of claim. And that was sent at 12 p.m.
Mr. Yasin, I think we would accept the chronology that you're giving.
Thank you.
I suspect that we are willing as well to accept certainly the presumption that the appellant would have known.
Thank you very much.
Okay, so what bothers me though is something that's slightly different, and that is now Mr. Gonzalez was appointed by the respondent, by your side. So really, you have the freedom to decide who will be the person that you nominate, that you say, recommend for appointment. The question that bothers me is whether it is possible for you, respondent, to choose somebody who is ineligible or incompetent in the sense of not being validly nominated to that position. So if the appellant had objected to your recommendation of Mr. Gonzalez, what then? Could the appellant have succeeded in getting him unseated or not appointed to the tribunal? I'm just trying to figure out.
Two things, Your Honor.
Yes.
They would have had to show, if he was going to object and say, look, I'm not moving, they would have had to show and give some evidence of his being biased. And there is absolutely no evidence or anything portrayed anywhere in any affidavit showing that Mr. Gonzalez was biased. Now, Your Honor, it's like
as my sister says, bias is a very loaded term. Maybe we're talking about the same thing, but let me put it there and you can tell me if we are. The notion is that if you have been exposed to the facts and the weaknesses and everything, you have come to a decision on the same facts, same issues, same parties. And you ask once again, to perform the same function, isn't it likely that you will come to the same conclusion? And if that is likely, how does that feature in question in terms of whether it is reasonable to say that you are quote unquote biased? It's not, bias is not prejudicial, but it's just saying that how the mind works, you're likely to come to the same conclusion you did before. So for example, in I think the H&L case, that point was made very clearly. I think it's paragraph 20 of the judgment, somewhere there.
I get one thing.
Yes. In my judgment, the mere fact that the tribunal has previously decided the issue is not of itself and to understand that they should approach every case with an open mind. That is not to say that if it is asked to redetermine an issue and the evidence and arguments are merely a repeat of what went before, the tribunal will not be likely to reach the same conclusion as before. It would be unrealistic, indeed absurd, to expect that the tribunal in such circumstances to ignore its earlier decision and not to be inclined to come to the same conclusion as before, particularly if the previous decision was carefully reasoned. The vice which a law must guard against is that the tribunal may approach the rehearing with a closed mind. So I'm just wondering, in light of that approach, is there anything that we should be concerned about in a situation where the arbitrator had already examined the issues, the facts, the law, etc., had come to a conclusion, and is then being asked to do the same thing over again in a second tribunal? It seems a little odd.
Well, Your Honor, as you stated and you just read in the decision,
Yes.
that the arbitrator or the judge would have considered the matter before coming to the first decision. And if he was asked to do it back again, he would be expected to do that again.
Yes.
Now, Your Honor, what we have here in this case is in the first arbitration, the appellant did not participate. The arbitrators took the evidence and they found, and I think they found $176 million plus. The second arbitration, Your Honor, they again did not participate. So it is
all the more reason to suspect that the same decision would have been arrived at, wouldn't you say?
Indeed, Your Honor, but what more can the arbitrators do? There's nothing more. If I could put it this way, it may be a bad example, but let's say you have a singing competition and there's 3 persons in that competition. One could sing, one who's a voice, and 2 are dumb. And the one that could sing, he's the only winner. What we have here is in the first arbitration, the evidence was produced. The second arbitration, the evidence was produced. And Your Honor, as we in this, if I could maybe of some assistance, refer you to the award that was made, and you will see how technical it was. Your Honor, the award marked off, too many things marked off here, Your Honor. It's an exhibit, Your Honor. My apologies, Your Honor.
It's perhaps unfortunate that you're not more proximate to Council Houston.
Yeah, indeed, Your Honor. Oh yes, Your Honor. I think I've got it here now. It's a page 354
Right.
of the record. My apology, Your Honor. And this record, Your Honor, will show that give the whole outline. They give all the dates where it also indicates that look, notice was sent to the ministry asking them to
12 a.m.
asking them to file their defense, and that was done. But the point I wish to make to you, Your Honor, is at page 356.
Yes.
The technical aspects that the tribunal would have to look at. And these are the culverts, excavation, delays, whatever it is, Your Honor. And so basically, this is what would have been at the first arbitration and again at the second arbitration. And these are matters, very technical matters for those arbitrators who are engineers to look at access.
I follow you very well, and I think it's probably in the interest of efficiency and economy to proceed in the way that was followed earlier. And certainly the cases seem to be on your side, the ones I referred to earlier. I was just wondering more conceptually about the issue. Now, this is not a good analogy. Maybe years earlier was better. But say you have a judge alone trial.
What type of trial, sir?
Judge alone.
Oh, yeah,
trial.
yes.
And the judge comes to a particular decision. Would it be tenable for that judge to sit again on that same dispute, same parties? Put away the issue of disclosure, which you have dealt with quite well. I'm just wondering whether it is consistent with our notions of justice to have that situation occurring. And of course, Mr. Hawk didn't give us much with respect to go on in terms of going contrary to the authorities. So I accept that point is there. But I'm just asking you whether that presents any conceptual problems for you at all.
Generally, once a judge does a matter and it is sent for a hearing, generally it doesn't go back before that judge.
Why not?
It may be that there had to be a determinant as to credibility of witnesses.
For example.
But in this case, this arbitration, it is not a credibility of witnesses. It is what you're looking at, the measurements and the extra work that was done. The whole problem that arose in this matter, Your Honor, after the contract was awarded, the ministry wanted extra work to be done. The extra work was done, and the dispute arose as to the cost that the respondent was asking for that extra work. And so in the award order, you've got the extra work. You've got what it was. And it was basically for the engineers to look at it. If I could also say, Your Honor, in the first arbitration, you had Mr. Gonzalez, you had a Mr. Marshall. The second arbitration, and in the first arbitration, it was unanimous. In the second arbitration, Mr. Gonzalez, Mr. Rutherford, and Mr. Veacock, again unanimous. Again unanimous. And when one goes to arbitration, Your Honor, a majority decision will count. And in this last arbitration, Mr. Veacock and Mr. Rutherford were not parties to the first arbitration. And so sorry,
Go ahead, please. No, please go ahead.
It was a full stop, but I didn't hear any.
Yeah, no, as I said, it was the conceptual issue that provided some discomfort for me, but I follow what you're saying, and no doubt I will have to consider what you've said. I think another of my colleagues wanted to have come in maybe a little earlier.
Yes, please, Your Honor.
If not, you can continue with your submissions.
Counsel, I just wanted to follow up on something. I'm looking at your submissions, the submissions on behalf of the respondent, and specifically around paragraph 32, where you raise the notion of the waiver red list that appears in the IBA guidelines on conflicts of interest in international arbitration. And the waiver red list does include prior involvement of an arbitrator in the dispute. And in response to that, you acknowledged, of course, that Mr. Gonzalez had a prior involvement as an arbitrator in the first arbitration, but you said, but there had been an express waiver of the appointment before Justice Prasad. Can you clarify what you're characterizing as the express waiver? Is the express waiver more specifically the absence of an objection? Is that what you're calling the express waiver?
I prefer to answer this waiver. There was no objection.
Okay.
There was no objection. The name was put forward, and initially there was no objection. The matter before Justice Rishi Prasad lasted for several months, and then there was reporting. No objection whatsoever. The arbitration started, and all the correspondence was sent to the ministry. No objection until the 28th of November, several months after. And the UNCICL rules indicate, Your Honor, that if you're going to be bound by the rules, once you have an objection, you must do it promptly, and you must do it within 15 days. And in this instance, Your Honor, as regards the red list, Mr. Gonzalez, there's no evidence he had any association with the respondent before. He never participated or had any, apart from this arbitration. I don't know whether that answers your question, Your Honor.
No, you've clarified, counsel, that essentially the submission that you're making there is that the lack of a timely objection, the absence of any kind of timely objection, in your view, constitutes essentially a waiver of the of an objection based on Mr. Gonzalez's prior involvement in the dispute as an arbitrator.
And there are several authorities which support that submission, Your Honor.
The timely objection coupled with knowledge or presumed knowledge.
Yes, Your Honor.
Yes.
And there is knowledge. There is knowledge.
Yes.
There's no doubt about it. I don't need to do that, Your Honor.
You're doing it earlier when I distracted you, but yes, okay.
Your Honor, I don't wish to carry much longer with the court. My respectful submission is that the appellant had sufficient knowledge, sufficient time to object, didn't. There is absolutely no evidence of biasness by Mr. Gonzalez. And when the appellant in the letter of the 28th of November says that they were not given the opportunity to present any evidence. How could they be given the opportunity when, despite notice being sent to them, they decide to stay away? And Your Honor, I'll ask you to bear in mind the notices that were sent by the chairman of the arbitration, telling them, look, you're in breach. Please submit it. You gave that deadline. They didn't. And it is strange, having done all of that, they still would wish to ask this court to overturn this arbitration. Your Honor, if there's anything else that I could assist the court, I would be happy to do so.
Would they have been in a stronger position, Mr. Yassin, if they had objected at the point at which the appointment was made?
Maybe have been, and in fact, Your Honor, Mr. Gonzalez made very well say, look, if you don't want me, I'm gone. You know, Mr. Howard, he said, look, I've now been appointed to work in the public service, and it's not right that I should be there. It's quite commendable of him. And Your Honor, when you look back at the first arbitration, and in the affidavit of Mr. Meerza, he said that several requests were made for the ministry to appoint the other arbitrator, but they didn't. And this seems, when you look back, it may be a deliberate ploy on their part. And in the second arbitration, after receiving all the notices, not responding, maybe some bright person said, look, this man was an arbitrator before, sit down and wait.
Yeah, we don't want to speculate too much.
No,
Yes,
no, sir. No, sir. No,
Thank
sir.
you. Thank you very much.
Mr. Juminasin, if I may, since we're talking about the appointment, and the chronology will help, and I think the record will help, but maybe you can clarify this for me. So going back to the summons before Rishi Prasad, Jay, after the non-response of the state at one point, I noticed that the list from which he appointed Mr. Rutherford, and this was something that was also raised at some point during the proceedings, I think including by the AG. The list from which he appointed Mr. Rutherford and Mr. Rutherford would then have been should have been the appointee of the state. That list actually came from the respondent. I wasn't clear when I looked at the record. I'll have to look at it again more closely, but I wasn't clear why or if there was an opportunity afforded to the state to furnish a list.
It was, Your Honor. The state.
And that's on the record?
Yes, that's in the fly sheet, Your Honor. That's in the fly sheet. You will see the absence of the state. Maybe you could go to that.
No, maybe you just refer me to the page. I don't want to delay the proceedings, but quite apart from the absence, I don't mean the absence. I noted that at one point, but was it simply because of the absence that he then asked the respond? Oh, Mr. Juminasin is gone.
Okay, well, let's see whether we can get him back. Madam Deputy Registrar, can we enlist the assistance of our IT department? You're muted.
Sorry, yes, President, we will do. We'll be making an effort. Thank you so very much.
Mr. Husty, is there any assistance
Your Honor?
rendered to us?
Your Honor, having regard to the direct nature of the Honorable Judge's question, I would resist the opportunity to speak out of turn in responding to the question posed by the Honorable Court.
Yes.
I think that we have
You are never
sufficient
out
time.
of turn. You're never out of turn, but I'm surprised that you resist the opportunity to speak.
My apologies, Your Honor.
Yes, that's fine. We're back now. Thank you, Mr. Houston. And you're happy to hear, Mr. Giovanni, saying that Mr. Houston made no submissions in your absence. So, please.
Your Honor, I'm sorry. There was a little power glitch here,
Yes.
and I had to restart back here. My apologies, Your Honor.
That's fine. So I think you're responding to Mr. Justice Balkan.
Yes, I was trying to the fly sheet, Your Honor. It's found on page 288 of the record.
Yes.
And at page 288, Your Honor, on the 22nd of April, Your Honor, you have Mr. Ramlachan, Mr. Smith, whatever, this, not to clear the bottom. And at page 289, Edward Gonzalez, court orders with relevant authority with a view of nominating arbitrator on behalf of the defendant, adjourned to 27th of April 2016. 27th of April, Your Honor, Mr. Ramlachan, Mr. Smith for the appellant, Mr. George Howard, agreed arbitrator to meet on the 8th of May 2016 at 1:30 p.m. Then the 12th of May, Mr. Justice Prasad, Mr. Ramlachan, no appearance by the respondent. Court appoints Mr. Edward Gonzalez and Mr. George Howard to meet within 7 days and nominate a third arbitrator. And 13th of May, order entered. 14th of June, Mr. Prasad, Justice Prasad, Mr. Ramlachan, Mr. Howard declines invitation. No appearance by the defendant.
Yeah, Mr. Jamandasan, my question is really though, so we know the chronology. The thing is, when it came to appointing someone from the side of the state, and they had initially appointed George Howard, who declined, right? My question is, eventually what happened is that Justice Prasad asked for a list, and that list came from the respondent, Mr. Meerza. So I'm curious, is there anywhere in the record which we can say that an opportunity was afforded to the state to provide a list?
I would say because of the non-appearance, the deliberate non-appearance of the state in not coming to court, it forced Justice Prasad to ask the respondent to give him a list and he will choose.
Okay, thanks.
Thank you very much, sir.
Yeah, Mr. Yassin, I'm just to get it right, on the 22nd of April, was not an order made to nominate an arbitrator? It says on behalf of the defendant. Was it that the order was that the defendant should nominate an arbitrator? Is that what you're speaking about with respect to the list? I'm trying because Mr. Smith for the defendant was there. Mr. Smith for the state. Is that the note that you have?
What date on the flight sheet are you looking, please, Your Honor?
I'm looking at the 22nd of April, 2016.
If I can read you, a quorum, R. Prasad, Mr. Ramlachan / applicant, Mr. Smith defendant, Mr. and it's a bit not clear at the bottom there, but it continues on page 290. Edward Gonzalez, court orders contact with relevant authorities with a view of nominating arbitrator on behalf of the defendant, adjourned to the 27th of April 2016. So I assume that this relevant authority would be the appellant in this matter for Mr. Smith to contact his relevant authority for them to appoint their arbitrator. And then the 27th of April, Justice Prasad, Mr. Ramlachan, Mr. Smith, Mr. George Howard agreed arbitrator, and then to meet on the 6th of May, matter adjourned, adjourned.
Yes, so see before you go on, so Mr. Howard's name did not appear on a list that you have ever seen.
No,
It
no.
simply came up in court.
He was nominated by the appellant.
Yes, I follow you. Thank you very much.
Thank you very much.
Anything further, colleagues?
I'm fine.
Thank you. In that case, we'll thank you, Counsel, for your submissions.
Thank you.
Thank you, sir. And ask Mr. Hawk, do you wish to make a reply?
No, please, Your Honor, unless there's something specific the court would want me to reply to. I just rely on what I've said in my submissions earlier. Obliged.
Yes. Colleagues? Well, no.
Nothing from me, President. Thank you.
Thank you. Thank you very much. In a minute, I will ask my elder sister to say a few words, because I think this is probably the last time we're going to be seeing each other in this term. But I'd like to thank you very much for your oral submissions. Naturally, we will consider them, take some time, and then inform you as soon as we've arrived at a decision. Thank you again very much. Madam Justice Rajnorthley, please.
Yes, I haven't been called elder sister in a while, but President, thank you. And on behalf of all of us on this chat, I do wish, on the behalf of the President, judges, and staff of the court, I wish you all the very best. I know not everyone celebrates the Christmas, so I want to be mindful and respectful of that. But I still do think that everyone goes into the new year with a lot of hopes and wishes for good health. I keep saying much wisdom. It will take much wisdom to get through the next few years that we have, and a lot of love and compassion for neighbor. And our neighbor, sometimes I think I heard that Pope Francis says that, our neighbor is that person who shows us love. We also are told to show love to those who don't show us love. So, President, that's my way of saying be good, do good, and bring a lot of love into the world for 2026. And I do wish you all very, very much the best. And for those who do celebrate the Christmas and any other holiday over this time, I also wish you the very, very best. Thank you, President.
Mr. President,
thank you, Judge.
Would you allow me to also wish you and all the members of the court and your other judges and your staff a very happy Christmas, good holidays. And Madam Justice Ragnar indicated that she hopes you do good. I think it must be assumed that you always do good, sir, and continue to do so. Wishing you all the best. And I really say this here, and I've said it before and say it again. I compliment the work that this court is doing, and I compliment the way, the position that the CCJ has taken in Guyana and in the other regions as our apex court. Thank you very much.
Thank you, sir. Mr. Hawke, you do have a right of reply. Do you wish to make use of it this time?
Your Honor, I can do no better than my learned senior, but I would wish the court, your president, members of the court, the staff of the court, all my colleagues, a wonderful and blessed Christmas. And, as Her Honor, Madam Justice Ragnar-Lee says, certainly we can do it a bit more kindness in the world. And I guess I'll go to Christmas remembering that and trying to enforce that into the new year. But thank you very much for hearing me always. And thank you all very much. Thank you. All the best.
Thank you, sir. And thank you all. Madam Deputy Registrar, would you mind closing the proceedings, please?
Thank you, President Anderson. Thank you, Madam Justice Rajnorthley. Thank you, Mr. Justice Jamada. Thank you, Madam Justice Ononiwu. Thank you, Mr. Justice Walken. Thank you, Counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.
Thank you very much.